Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to go back over the last couple of weeks. There's been a bunch of posts. Some content creators got all hot to trot about this too, about the United States Department of Justice moving to dismiss a large capacity magazine conviction against the defendant in the District of Columbia. Is it good news? Yeah, it's certainly not bad news. Many people made it out to be a momentous occasion. Maybe it was, but maybe it was momentous for another reason, because rather than seeing the glass as half full, there's another way to look at it, and that is, yeah, maybe the glass is half empty. We'll connect all the dots for you in just a moment. So today, let's spend a few minutes and let's talk about, is there a hidden meaning in DOJ's position on mag bans? Okay, America, this is what we're talking about. We're talking about a case that took place out in the District of Columbia. Prosecution started with the previous Department of Justice. It has now been assumed by the current Department of Justice. There has been a change in attitude. The case is Benson versus the United States. The big news is that of the many charges that Mr. Benson had been convicted of, and there were many, one of them was a violation of Code of the District of Columbia, Section 7-2506.01b, which is a criminal prohibition against possessing any magazine which holds more than 10 rounds. He had been found guilty of that. The United States Department of Justice, in their motion to actually dismiss that count against Mr. Benson, wrote as follows. On appeal, Benson challenged the validity of D.C. Code Section 7-2506.01 on Second Amendment grounds, among other issues. Although the United States initially defended that provision against constitutional attack, the United States has changed its position as to the validity of this statute under the Second Amendment, as outlined in the D.C. Appellate Rule 28K letter filed by the United States on July 24th, 2025. Given the United States' view that a complete ban on large-capacity ammunition feeder devices, as defined in D.C. Code Section 7-2506.01, cannot survive constitutional scrutiny, we respectfully move this court to vacate Appellate Benson's conviction pursuant to D.C. Code Section 17.306 and to remand to the Superior Court so that the United States may move for dismissal of that count pursuant to the Superior Court rule. Okay, pretty cool. Yeah, except remember I said at the very beginning he'd been convicted of possessing a large capacity magazine and several other counts? Yeah, well, when you read the proposed motion and order by the United States Department of Justice, you'll notice that nothing else is mentioned here at all. So what else was Mr. Benson convicted of? Well, he was convicted of carrying a concealed weapon without the appropriate license under D.C. Code Section 22-4504A1. He was also convicted of possessing an unregistered firearm under D.C. Code Section 7-2502.01a. And he was convicted of unlawful possession of ammunition under D.C. Code Section 7-2506.01a3. So you see, there's this rule of statutory construction that you learn in law school. It's called expressio unius est exclusio alterius, which is just the fancy Latin way of saying the inclusion, the intentional inclusion of something means to the exclusion of all others. So while the United States Department of Justice clearly has a problem with the constitutionality of the District of Columbia's magazine ban, they apparently do not have the same concerns as to these statutes and these charges right here that Mr. Benson was also convicted of, which means that they don't have any constitutional problem with the following statutes. Section 22-4504A1. No person shall carry within the District of Columbia, either openly or concealed on or about their person, a pistol without a license issued pursuant to District of Columbia law or any deadly weapon or dangerous weapon. Whoever violates this section shall be punished as provided in Section 22-4515. 1. A person who violates this section by carrying a pistol without a license issued pursuant to the District of Columbia law or any deadly weapon or dangerous weapon in a place other than the person's dwelling, place of business, or other land possessed by the person shall be fined not more than the amount set forth in law or imprisoned for not more than 5 years or both. Again, that's concealed carry licensing, so maybe that's not really sticking their neck out too far. But then I want you to consider what else the Department of Justice apparently has no problem with. Section 7-2502.01, registration requirements. Except as otherwise provided in this unit, no person or organization in the District of Columbia shall receive, possess, control, transfer, offer for sale, sell, give, or deliver any destructive device, and no person or organization in the district shall possess or control any firearm unless the person or organization holds a valid registration certificate for the firearm. Okay, so is the United States Department of Justice saying that registration of firearms is okay, because that would actually be in violation of another huge piece of federal legislation called the Firearm Owners Protection Act, but I digress. They also apparently don't have a big problem with Section 7-2506.01, persons permitted to possess ammunition. No person shall possess ammunition in the District of Columbia unless 3, he is the holder of a valid registration certificate for a firearm pursuant to subchapter 2 of this chapter, except that no such person shall possess 1 or more restricted pistol bullets. So, the good news is the United States Department of Justice believes that a ban on any magazine which holds more than 10 rounds is standing alone unconstitutional and no person should be prosecuted of it. That is good news. However, the inclusion of one is to the exclusion of all others. If that is the case, then the United States Department of Justice has no problem with concealed carry licensing under DC Code Section 22-4504, requiring registration of firearms under DC Code Section 7-2502.01a, requiring registration in order to possess ammunition under DC Code 7-2506.01a3. So while the news on the large capacity magazine was in fact good news, it really wasn't news though, was it? Because let us remember that the United States Department of Justice had not only filed an amicus brief, they had also requested oral argument time and received it in the matter of Harrell v. Raoul and Barnett v. Raoul that was argued before the 7th Circuit. So again, the move in Benson here was consistent with previous moves made by this Department of Justice. But America, does it concern you that the United States Department of Justice, when given an opportunity to look at some pretty crazy District of Columbia gun laws, that they had no problem with it at all? And that is why maybe what the Department of Justice did in the matter of Benson versus the United States is not really good news. Okay, listen, we're going to go ahead and link up the unopposed motion by DOJ down below so that you can geek out on it for yourself. Don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there. Tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.